Welcome to the Firearm Firm channel. Another huge victory for the Second Amendment came out of Texas this past Sunday when a federal judge decided that ATF exceeded their authority when it comes to ATF's final rule on unfinished frames and receivers, or what we commonly refer to as 80% lowers. Now, if you think ATF finally needs to realize that they can't just do whatever they want just because they have a president telling them they can, be sure to smash that like button. And while you are clicking on that like button, be sure to go ahead and click on that subscribe icon located in the bottom right hand corner of this video so you can subscribe to the Firearm Firm channel. I previously did a video about Polymer 80 fighting back against ATF's final rule on frames and receivers back in January of this year. Now, if you have not had the chance to view that video, be sure to check it out by clicking on the link above. For those of you that are not familiar, here is a quick rundown on what has happened with unfinished frames and receivers up until today. In April of 2022, ATF published a final rule which changed the definition of a firearm and frame or receiver from the original definitions Congress gave them in the Gun Control Act of 1968. The GCA defines a firearm as any weapon, including a starter gun, which will or is designed to or may rarely be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, or any destructive device, but does not include antique firearms. Under the GCA, a frame is defined as a part of a handgun or variants thereof that provides housing or a structure for the components designed to hold back the hammer, striker, bolt, or similar primary energized component prior to initiation of the firing sequence, even if pins or other attachments are required to connect such components to the housing or the structure. The GCA defined a receiver as a part of the rifle, shotgun, or projectile weapon other than a handgun or variants thereof that provides housing or a structure of the primary component designed to block or seal the breech prior to initiating of the firing sequence, even if pins or other attachments are required to connect such components to the housing or structure. In their final rule, ATF added the following sentence to the end of the GCA definition of a firearm. The term shall include a weapon parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. The final rule also changed the definition of frames or receivers to include partially complete, disassembled, or non-functional frame or receivers, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. Polymer 80 filed a lawsuit against ATF in January of 2023 in the United States District Court for the Northern District of Texas. On March the 7th, Polymer 80 filed a motion for temporary restraining order and preliminary injunction against ATF's final rule that 1. ATF has exceeded its statutory authority by creating and implementing a new definition of firearm that contradicts the plain language of the Gun Control Act, and that ATF's attempt to implement the regulations are arbitrary and capricious. Number 2, the final rule violates Polymer 80's First Amendment rights because the regulation is content-based restriction on protected speech that cannot pass strict scrutiny. Number 3, the final rule, in conjunction with ATF's letters, violate Polymer 80's Second Amendment rights by regulating constitutionally protected conduct in a way that is inconsistent with the nation's historical tradition of firearm regulation, contrary to the Supreme Court precedent. And finally, the final rule, in conjunction with ATF's letter, violate Polymer 80's Fifth Amendment rights because they effectuate a regulatory taking without just compensation and deny due process as impermissibly vague. In order for a court to grant a temporary restraining order, which is a form of a preliminary injunction, the party seeking the preliminary injunction must show the following 4 things. 1, that there is a substantial likelihood of success on the merits. Number 2, a substantial threat of irreparable harm. Number 3, the balance of hardship weighs in its favor. And number 4, that the issuance of a preliminary injunction will not disserve the public's interest. For our discussion today, we are only going to focus on whether or not Polymer 80 showed a substantial likelihood of success on the merits. The court found that there was a substantial likelihood of success on the merits in that the final rule exceeds the scope of ATF's statutory authority. In the order, the court wrote, plaintiff contends that ATF's final rule and its implementation of the regulation exceeds the agency's statutory authority under the plain language of the GCA because the redefinition of frame or receiver and treatment of parts are inconsistent with the Act's plain language. Plaintiff is correct. The court went on to write, the final rule's redefinition of frame or receiver conflicts with the statute's plain meaning. The definition of firearm in the Gun Control Act does not cover all firearm parts. It covers specifically the frame or receiver of any such weapon that Congress defined as a firearm. That which may become a receiver is not itself a receiver. Congress could have included firearm parts that may readily be converted to frames or receivers, as it did with weapons that may readily be converted to fire a projectile, but it omitted the language when talking about frames and receivers. When Congress includes particular language in one section of a statute, but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. Likewise, when Congress uses a phrase in one part of a definition and excludes that phrase from another part of the very same definition, courts should give the effect to Congress' deliberate exclusion. The final rule contains its own definition of firearm, notwithstanding that the GCA already defines the term. Under the final rule, the term shall include a weapon parts kit that is designed to or may rarely be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. That language conflicts with the statute's definition of a firearm. But the final rule grants ATF the general authority by copying language used throughout the statutory definition. It takes phrases like designed to and may rarely be converted and assembled from various places in the statute, cobbling them together to form ATF's own definition of a firearm. Those terms may add a patina of credibility to the drafting, but they tarnish Congress's carefully crafted definition. More importantly, they unlawfully expand ATF's authority beyond the boundaries set by the Act. Finally, as to the issue, the court wrote, in sum, the gun control's precise wording demands precise application. Congress could have described a firearm as any combination of parts that would produce a weapon that could fire a projectile. It used this language elsewhere in the definition. Congress could have described a firearm as any part designed to be part of a weapon. It used language too. Congress could have described a firearm as a set of parts that may be rarely assembled into a weapon, as it did for destructive devices. Congress could have written all other things, and the very definition of firearm demonstrates that Congress knew the words that would accomplish those ends. But Congress did not regulate firearm parts as such, let alone part kits that are designed to or may rarely be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosion. The court did find that Polymer 80 met their burden and did grant a temporary restraining order and preliminary injunction. Not only is this great news for Polymer 80, it is great news for the Second Amendment community. If you have any questions about this video or any other Second Amendment related questions, be sure to leave them down in the comments section below, or you can email your questions directly to us at questions@thefirearmfirm.com. Until next time, stay armed and educated.